When your loved one passes away in North Carolina, you might be wondering, do I need to go through formal probate or is there a simpler way? I'm Ashley Palmer, CPA and Estate Administration Paralegal with the Walls Law Group, and today I'm here to break down the differences between informal and formal probate in North Carolina and help you figure out which path might be right for your family. Here's what I hear from families all the time. We just lost mom and now someone's telling us that we need to go through probate. But we've also heard about something called informal probate or a small estate procedure. What's the difference and how do we know which one we need? The truth is, not every estate in North Carolina requires the same level of court involvement. Understanding your options can save you time, money, and stress during an already difficult time. Let's start with formal probate. This is what most people think of when they hear probate court. In North Carolina, formal probate is the full estate administration process that requires ongoing court supervision. Here's when you'll typically need formal probate: when there's no will or the will is being contested, when the estate includes real property in multiple counties or jurisdictions, when the estate value exceeds certain thresholds, when there are disputes among family members, and when creditors are making claims against the estate and you want to forever bar any future claims. During formal probate, you'll need to file an application for letters with the court, publish a notice to creditors, file an inventory of the assets of the estate as of the date of death, and ultimately submit a final accounting to the court, which includes every penny that comes into or goes out of the estate. This process typically takes 6 months to several years, depending on the complexity of the estate. In North Carolina, the average estate takes about 18 months. Now, informal probate, or what we sometimes call simplified probate, is designed for smaller, less complex estates. In North Carolina, this involves the small estate affidavit process under North Carolina General Statute 28A 25-1. Here's when you might qualify for informal probate. The estate value is under $20,000 or $30,000 if the surviving spouse is the sole heir. The deceased person has been dead for at least 30 days. No formal estate administration has been started. The person claiming the property is entitled to it under the will or intestacy laws. With a small estate affidavit, you can often collect money, personal property like vehicles, without going through full court supervision. The process is faster, about 3 months, and significantly less expensive. So what are the key differences you need to know about? Formal probate requires ongoing court supervision and regular filings, at least a total of 3 court filings. Informal probate typically involves 2 affidavits and minimal court interaction. Formal probate usually takes 6 months minimum in North Carolina, often 18 months or much longer. Informal probate can be completed in about 90 days. Formal probate involves court filing fees, potential attorney fees, and administrative costs. Informal probate is significantly less expensive. Formal probate requires extensive documentation and court filings. Informal probate doesn't require nearly as much documentation. The key is understanding which process fits your specific situation, and that's where proper legal guidance becomes crucial. Remember, every family's situation is unique. While informal probate can be a great option for smaller estates, you don't want to miss important deadlines or make costly mistakes by choosing the wrong process. If you're dealing with a loved one's estate in North Carolina, don't navigate this alone. At the Walls Law Group, we help families understand their probate options and choose the most efficient path forward. We have developed a list of factors that help us evaluate and determine the best pathway to proceed with each unique probate case. I'll link to our probate resources in the description below, and if you found this helpful, please like and subscribe for more North Carolina estate planning and probate guidance.